If you want contribution, get the third-party release. The maritime version of Murphy's Law can be a potential trap for participants in maritime tort litigation. The decision of the 11th Circuit Court of Appeals in Murphy v. Florida Keys Electric Co-op Essex enunciated the rule that in order to preserve the right to pursue third parties for tort contribution, a party must negotiate a release of those third parties when settling the underlying claim brought by the tort victim. The law enacted by the Murphy Court was based upon the proportionate fault rule existing in the maritime law and the pro rata credit rule established by the U.S. Supreme Court in McDermott Incorporated. The logic of this version of Murphy's Law is that the settling tortfeasor is, per McDermott, deemed to have paid to the tort victim only in accordance with the settler's own proportionate share of fault. The settlement extinguishes the right and needs of non-settling tortfeasors to pursue the settler because it coincidentally limited the non-settler's liability despite the doctrine of joint and several liability to their own proportionate fault. The Murphy case held that unless the release negotiated between the settler and the tort victim also releases the tort victim claim against the non-settler, the settler is presumed to have paid only for its proportionate share and cannot seek contribution from other. This rule has subsequently been adopted by the Fifth Circuit Court of Appeals in Orme Dimer Transportes Maritimus. The Fifth Circuit has also gone so far as to say that the formal assignment of claim from the tort victim to the settler would not remedy the situation. See also Lexington Insurance. Recall the McDermott v. M. Clyde case arose from a situation where one the named defendant to a lawsuit had settled, but the case continued on against remaining named defendant. The question was how much settlement credit should be awarded to the remaining defendant. Given the existing U.S. maritime law since the reliable transfer case of a tort system of proportionate default, the Supreme Court decided in McDermott that the verdict against the remaining defendant would not be reduced simply by the dollar amount paid by the settler, but would be reduced instead by the proportion of fault eventually attributed to the settler by the fact finder, be it judge or jury. This rule made it unnecessary for the non-settling defendant to keep alive their cross-claim for contribution against the settler, thereby assuring that the settling defendant had terminated its involvement in the lawsuit with finality. At the same time, the tort victim would get fair compensation. The 11th Circuit Court in Murphy recognized that if, under McDermott, the settling defendant is deemed to have only paid his proportionate share or fault, he can have no reason to seek contribution from other. The right to contribution is purely and primarily a creature of the maritime law rule of joint and several liability, under which the plaintiff is free to collect the entirety of its verdict from any one of those tortfeasors who proximately cause his harm. If a tortfeasor is forced by the rule to pay for more than its proportionate share, the right of contribution exists to allow him to collect contribution from the other tortfeasor in accordance with the determined share. But the McDermott presumption means that the paying entity isn't entitled to contribution because it didn't pay more than his fair share. There are various ways in which this rule can hurt the unwary, particularly in situations where, for one reason or another, all potential tortfeasors cannot be joined by the victim in one action. For example, where a cargo owner is bound per the term of a bill of lading to bring an action against the carrier in a foreign arbitration forum, potential additional tortfeasors such as the loading or discharging stevedores, packaging companies, or truckers could not be brought into the arbitration forum against their will. If the cargo owner and carrier effect a settlement, the carrier may have hopes of bringing suit at a later date to recover some portion of the settlement amount it was required to pay to the cargo owner, unless the carrier obtained a release of the cargo owner's claim against the prospective contribution. However, the carrier will be presumptively deemed to have paid to the cargo owner only an amount relative to the carrier's own proportionate fault. The carrier could not therefore sue a loading stevedore or trucker for contribution even if the carrier obtained a formal legal assignment of the cargo owner's claim. Another example might be a John Act claim brought by a seaman for personal injury suffered during the course of his employment. If such action is brought in federal district court in which other potential contributors are not subject to jurisdiction, the vessel or owner employer cannot expect to later obtain contribution from any third parties unless the seaman has released his or her claim against them, indicating that the vessel owner paid for not only its own proportionate share of fault but also additional amount on behalf of other tortfeasor. Of course, contribution fraternal twin cause of action is indemnification. Neither Murphy, Ondemer, nor McDermott serve to forbid the pursuit of indemnification from an unreleased non-settler, and there would seem to be no logical reason why those rules should be extended. Of course, the famous word of Justice Oliver Wendell Holmes Jr. to the effect that the life of the law hasn't been logic. It has been experienced. My counsel again relying upon logical extension. The theoretical basis of the right of indemnification differs greatly from that underlying the right of contribution. A settling tortfeasor might be forced to pay the full amount of a claim by virtue of its relationship with the claimant and might have a contractual or quasi-contractual right of full indemnification from a third party. In such a case, the payer would not be limited to a mere contribution claim and would not be deemed or presumed with its own proportionate fault. Maritime law recognizes several types of indemnity, both contractual and quasi-contractual, and, in tort, via the so-called active or passive construct. For example, a vessel owner might be liable to a seaman for injuries arising as a result of an unseaworthy condition on the vessel. If that condition was caused to occur by the failure of an expert stevedore or contractor to live up to its warranty of workmanlike performance, the vessel owner could seek indemnification from the stevedore or contractor without having secured a release for them from a seaman. Therefore, one should find oneself in a situation of wanting to recover monies paid in the settlement from parties that were not able to be drawn into the initial claim process. Thank you.